Let's talk about this recent case from Hawaii. This is a lawsuit against TransUnion where TransUnion was arguing that even though they did false credit reporting on a discharged account, discharged through bankruptcy, that the plaintiff, the consumer, should still lose the case. And this was denied by the district court judge. I want us to look at this for a couple reasons. One, has a pretty in-depth analysis of standing, which is just a huge problem in any type of consumer case. Now, the rather simple solution is, and something we've been doing for many years, is we file everything in state court. And so we don't really deal with standing in federal court, and I'll get to that in a moment. But then I want you to see the different types of claims that you can make related to incorrect credit reporting on a bankruptcy discharge debt. And then finally, I want you to see how you really have to plan out how you plead something, how you put the words into the complaint, into the lawsuit, to account for different possibilities and alternatives. And we'll see how important that is because the plaintiff, the consumer, did a good job in this case. All right, so let's go ahead and jump right into this. So we'll see this is a motion for judgment on the pleadings, very similar to what's called a motion to dismiss. And there's really two grounds here. One, the plaintiff, the consumer, lacks standing. And then number two, there is no sufficient allegations of a 1681 EB. This is what's called the maximum possible accuracy or reasonable procedures claim under the FCRA. So we'll jump right into this. All of this has been denied. So what is Article 3 standing? Well, this is simply saying that under Article 3 of the Constitution, you have to have a case or controversy, and that has been interpreted to mean you have to have these three elements. So there's an injury in fact, so you have to be damaged. Number two, we have to be able to trace the damage back to the supposed bad conduct of the defendant. And then number three, there has to be the ability to be redressed by a favorable decision. All that means is there has to be something the court can do. In other words, if I was in a car wreck and I did not sue for damages, but I sued that the court would turn back the hands of time, create time travel so I wouldn't be in that car wreck, well, the court can't do that. There's no ability for the court to redress or to take care of me in that situation. So these are the three elements. Almost always in these consumer cases, the argument is over the first element. So here the court says it has to be concrete and particularized, not conjectural or hypothetical. I'll say this, judges are all over the board about what these words mean. And so this gets very complicated. A lot of this is sort of in the eye of the beholder, which again is one reason why we always bring our claims in state court. So when the defendant transfers or what's called removes the case to federal court, they have to convince the federal judge that there is standing. So whoever sort of knocks on the door of the federal courthouse has to prove standing. And since we never seek out federal court, we don't have to prove that. Now, if there's no standing, then it goes back to state court. All right, so we've got the second element is causation. In other words, can you show that something the defendant did, that's likely what actually caused your injury here? And these are some sort of technical legal terms, proximate causation. Basically, this whole idea of causation is not terribly hard. And the third element, redressability, I think in a footnote or later on it says, that wasn't attacked and it clearly can be redressed by awarding damages. Okay, so there's two types of attacks. And again, I don't normally do this on these types of cases, but I do want to just this one time, and maybe we'll do it again in 6 months, kind of go over this standing issue. So two ways to attack standing. One is called a facial, which is just say, let's look at the face of the complaint and let's look at that. And then the other is factual, where we're going to bring in evidence from outside the complaint or the lawsuit and show to the judge that there is no standing. So facial attack, defendant disputes the truth of allegations And, so here we have TransUnion also appears to dispute the truthfulness of the allegations because they say, well, you could not have been damaged by this. It defies common sense to conclude that this caused any damage. And the argument here is they said, well, we actually made your credit reporting better than it would have been. And the judge says, but, doing this factual challenge where you argue against what the plaintiff put in the lawsuit, that fails because you didn't provide any extrinsic or outside evidence. So that's no good. And so then we say, well, the facial challenge fails because the allegations are sufficient. In other words, it talks about emotional distress, talks about anger, talks about damaging a credit score. And so that is enough here. All right, so here's the argument about actually improved the rating. And the judge says, well, that might be true. Okay, so it was reported as an outstanding current obligation instead of a discharged obligation. And the judge says, it could be true. Let's see. It could show that the non-delinquent Wells Fargo was a positive factor. Or it could show that it decreased the credit rating because it inflated the debt to income. So debt to income is how much debt do I have compared to my income? Well, if there's a discharged debt, then that shouldn't be factored in. But if it's reporting as current, then it's factored in. So this may not affect, although the judge says here, factor influencing credit scores. It's not really affecting the credit score so much. It would affect the underwriting. In other words, I might have a good credit score, but then when the underwriting looks at my, for example, mortgage application, they say, well, hey, John, you got too much debt. It's consuming too much of your monthly income. So I can be damaged even though it doesn't affect my credit score. It may affect my ability to go get credit. And all of this is talking about simply economic damages. We also have the emotional distress damages. It says, or the evidence could show, regardless of the effect on credit score, the lenders named, evaluated independently and found the debt warranted an adjustment of lending terms unfavorable. And so the court says, because there are these possibilities and they are plausible, then I must accept the plaintiff's allegations. All right, so let's go down here and we'll talk about the two types of claims against a credit bureau. Now, we're not talking against a furnisher, so like Wells Fargo or Midland Credit or Portfolio Recovery. We're only talking about against a credit bureau. So here are the two primary claims in this area of the Fair Credit Reporting Act. We have EB and I. EB is maximum possible accuracy or reasonable procedures. I is when you send a notice directly to the credit bureau. In other words, not going to Wells Fargo and then Wells Fargo notifies the credit bureau, but you go directly to the credit bureau and you say, hey, something's wrong. Well, now they have to investigate. So just think I for investigation. All right, so let's look here. One claim is reasonable procedures under EB. So this is only when a credit bureau prepares a report that they're going to sell or provide to a user, like a car dealer or Capital One who pulls your credit report twice a month to make sure that they don't need to adjust your credit limit, things like that. Consumer Reporting Agency prepares a consumer's report. It shall follow reasonable procedures to assure maximum possible accuracy of the information. Another claim is the reinvestigation. They call it reinvestigation because, at least theoretically, we believe the credit bureaus investigate the information before it goes on to your report. Not exactly true. But anyway, it's called reinvestigation. You can just remember it, though. It's an investigation. You notify TransUnion, say, investigate this. They do an investigation. That's under Section I, 1681I for investigation. So disputed accuracy from a consumer, the agency, talking about the credit bureau, shall conduct a reasonable reinvestigation, determine whether the disputed information is inaccurate, and record the current status of the disputed information or delete the item from the file. So here the consumer only asserts this EB claim. And TransUnion says, well, it's not enough because the plaintiff must also show did not follow reasonable procedures. And TransUnion says, well, it can't be unreasonable because we got the information from a source that that it reasonably believes is reputable. In other words, Wells Fargo. And so they say TransUnion argues if it allegedly received inaccurate information from Wells Fargo, then it acted reasonably. The court says that's a cute theory, wonderful argument, except the plaintiff does allege you took unreasonable procedural actions. So here's where we start to get into these alternatives, and it shows you how important this is to plead in the alternative. So I'll give you a simple example. When we sue a credit bureau and then we sue the furnisher, we'll say the credit bureau has an obligation, which is true, to forward the dispute or to notify the furnisher. So Capital One, for example. So, hey, John Watts is disputing the Capital One account. Here's what he's disputing. They have to notify Capital One. Only if they notify Capital One can I then sue Capital One under the FCRA. So I have to allege that they notified them, but I don't know. See, I don't know because that's all happening secretly between these two companies. So I also allege that they did not notify. So on the one hand, we say they notify Capital One as required by the FCRA. The next paragraph will say, alternatively, they did not notify Capital One. Well, if they did not notify Capital One, I can't sue Capital One. But it makes my claim better against the credit bureaus. If the credit bureaus did notify the furnisher, now I can sue both of them. So occasionally we still get lawyers, even though they know better, who will say, well, this is a contradiction. Well, of course it's a contradiction. That we're explicitly told in the rules we can plead things that are contradictory because we're pleading it now, not having put anybody under oath. We got to go take the deposition of TransUnion or get their documents to find out, did they notify Capital One? So notice what the plaintiff did here. The TransUnion did not perform an accuracy check on the information from Wells Fargo, which TransUnion knew furnished inaccurate information. So the allegation is you guys know Wells Fargo is terribly unreliable on discharged debt. Alternatively, Wells Fargo told TransUnion it had been discharged, but TransUnion rejected or otherwise overrode the communication they received. Now, see, those are contradictory. On one hand, Wells Fargo didn't tell you it was discharged, and you should not have trusted that because you know they're unreliable. Alternatively, Wells Fargo did tell you that this was discharged in debt, and you just ignored it. Here's another alternative. Assuming Wells Fargo did not furnish information to TransUnion allegedly extracted information from the bankruptcy court dockets and failed to employ reasonable procedures to ensure it updated debts after Chapter 7. So they're saying, look, you guys knew about the bankruptcy. You're reporting the bankruptcy. You should have looked into the bankruptcy docket, the information that's there, and figured out, hey, Wells Fargo was included in bankruptcy and discharged. And the court says all three of these alleged alternatives are plausible. So first, it would be unreasonable to not look beyond information furnished to it when that comes from an unreliable source. So all the judge is doing is just sort of tracking these. So here's the first one that matches up here. So if TransUnion knew Wells Fargo was unreliable as alleged, then neglecting to corroborate that constitutes a failure. The second alternative under which Wells Fargo is not unreliable, if Wells Fargo communicated that the debt had been discharged and TransUnion ignored that, they would have failed to follow reasonable. So you see what the judge is doing. He's just saying, hey, the plaintiff has alleged three alternatives. Let's look at number one. Yep, that would qualify. Number two. Yep, that would qualify. All right, and then he's going to give just a cite here. This is from New York. Experian received copy notification through eOscar, which contained updated and corrected information, but they did not use that. That would be a violation. Here's the Calvillo versus Experian, plausible claim where plaintiff alleged Experian had inaccurately reported a bankruptcy discharge by disregarding other information. All right, third. Now here's the third alternative. If TransUnion did not receive the information from Wells Fargo, but instead determined outstanding debt status from the docket of the bankruptcy case, and again, the docket's just kind of like, think of a physical sheet that lists everything and it's got all the pages behind it. Plaintiff plausibly alleges TransUnion failed to follow reasonable procedures, so TransUnion assumed the Wells Fargo account a pre-petition. That means the account was open, was created before the bankruptcy was filed. So in a Chapter 7, almost always every debt, except certain things like student loans and other things like that, but all pre-petition debts can be assumed to be discharged. So TransUnion assumed that this pre-petition debt would survive a bankruptcy when that's rare. Treated the Wells Fargo account as being reaffirmed. Reaffirmed is where your debt would be discharged, but you tell the court, special procedure for this, you say, I want to be obligated again on this debt. I do not want to be discharged. I want to reaffirm, to reestablish this debt. And so they're saying TransUnion treated that as being reaffirmed despite there being no evidence of that in the bankruptcy docket. And so they go, the judge says, well, see, all those are reasonable alternatives. And so the test is, has there been a plausible pleading or plausible allegation that you guys at TransUnion violated Section EB, the reasonable procedures for maximum accuracy? And here's a little footnote. Third alternative, TransUnion cannot prevail as a matter of law, even though court dockets are presumptively reliable. So what this is talking about is TransUnion will say, well, hey, we can rely on the court documents. And the plaintiff and the court are saying, yeah, that's right. We're not saying that there was wrong information. We're saying you misinterpreted the docket. So credit reporting agency is not liable under FCRA for reporting inaccurate information obtained from the document absent prior notice. But that also means you have to actually rely on it. So you have to properly read it and interpret it. Okay, so this is an interesting argument. The credit bureaus like to make this argument. They know it's bogus. They continue to make it because sometimes people bring these lawsuits and don't know this, and they fall for this trick. So the TransUnion is saying, well, you didn't give us notice before you file suit, and you have to do that. So here's the argument. You cannot be liable under the FCRA because any remaining liability and reasonable procedures claim, that's an EB claim, would require it to have disregarded notice of inaccuracy, blah, blah, blah. And because liability would also require plaintiff to have given notice of dispute. Of course, this argument is misplaced given the court has rejected the contention that the allegations are insufficient. Okay, and if you want, so here's the deal. You do have to give notice under an I claim. Remember, I is for investigation. Well, yes, with that, you do have to tell the credit bureaus, hey, there is inaccurate information. I want you to investigate it. I want you to fix it or delete it. And so this is just talking about, this is not frivolous, even though it's wrong what TransUnion is making. Now, there'll come a point in time where I think courts will say, okay, guys, seriously, enough is enough. So this was denied, and then the case is continuing. I think I looked the case up, and maybe now it's been settled with TransUnion, and it's moving forward with Experian, I believe. So anyway, that is this case from August of this year from the amazing state of Hawaii. And hope that if you are dealing with either the FCRA, which I presume you are, you wouldn't have made it this far in this video, particularly dealing with discharged debt, that this will be helpful to you. And also just sort of the theory, the idea, the concept, strategy of how to plead a case to deal with these types of arguments from the credit bureaus. Okay, guys, thanks for watching this, and I'll catch